Quebec's controversial secularism law, Bill 21, is headed to the Supreme Court, and the federal government and more than one province will weigh in on Quebec's use of the notwithstanding clause to impose it. This is the part of the charter that allows lawmakers to override some charter rights. Alberta, Ontario, and Saskatchewan, all provinces that have used the clause, have filed in support of Quebec's position in the way it used it. Meanwhile, Manitoba has just intervened against it. Manitoba Premier Wab Kinew joins me now. Premier, it's good to see you. Thanks for taking the time on this.
Thanks for having me back.
Why was it so important for Manitoba to intervene on this case?
Well, I think there's an important constitutional question that needs to get settled. But I think on the face of it, here in Manitoba, we are not fans of Bill 21. We have turban-wearing Sikhs. We have Hutterites who wear headscarves, Muslims who wear hijabs, Christian people who wear the cross. And we have a lot of secular folks, a lot of atheists even, who are concerned with suspension of charter rights. So, you know, just in that very direct way, we're standing up for people in our province and what we want our confederation, our Canadian public sphere to see reflected when it comes to this question about secularism and separation of church and state, but also importantly about the freedom of religion. So we brought forward this intervention, and effectively what we're arguing is that the final word should always be with you, the voter. Yes, you elect people to parliament and to legislatures across the country, and they can use the notwithstanding clause. But in our intervention, we're arguing that courts should still be able to rule on whether these laws would be considered unconstitutional outside of the use of the notwithstanding clause. So again, a court would not have, if our intervention is successful, a court would not be able to strike down a law that's using the notwithstanding clause, but they could still say that if it weren't for Section 33, this would be unconstitutional. The thinking behind that is, now with the experts on the bench ruling about the constitutionality otherwise of these provisions, you, the voter, now have that piece of information the next time you go to vote. And if you agree or you don't agree, you can express yourself in the ballot box accordingly. And so I think that's a really, really important piece of information for our democracy to maintain its vitality, but also importantly, so that we can ensure that there is some contemplation of the rights of vulnerable minorities in our society.
So you're not looking to necessarily restrict the use of the notwithstanding clause, because this is the argument Alberta, Ontario, Quebec, and others are making, that this is a necessary balancing, you know, of the federal and provincial powers and giving final say to legislatures and the democratically elected people. But they need to be held accountable formally, essentially, in that a judgment is passed on their actions, whether it can strike it down or not.
Exactly. This is about accountability, and it is pretty clear, particularly within the confines of how this case is going to be adjudicated at the Supreme Court, that the notwithstanding clause, it's a constitutional reality. But the final arbiter should always be the democratic will of the people. And so, you know, previous Supreme Court decisions have talked about a dialogue between the different branches of government. So if you're picking a dialogue in this case, well, maybe the parliament or a legislature decides to respond to a court saying that this would be unconstitutional. They use the notwithstanding clause. Well, okay, now maybe the judicial branch has the ability to weigh in again, not to strike down, but to say, other than Section 33, these provisions would be unconstitutional because they would potentially violate people's charter rights in these ways. And then it's up to you. Again, the next time you go to the ballot box, if this reflects the democratic will of your province or of the country, then you should have that ability to support it or to strike it down by electing a new government that would change the law. And so to me, given the constitutional reality of Section 33, I think putting the power back in your hands as a voting member of the public is the best way for us to ensure accountability for people passing laws that use Section 33, but also to have the ability for a vulnerable minority to have their voice heard, to be able to make their case first in the court of law and then in the court of public opinion.
So there are two other issues I'd like to explore with you, if I could, in the time that we have. One is the clarifying request the federal government has made in its factum on the repeated use of the notwithstanding clause. Because when it's invoked, it lasts for a term of 5 years, and then a legislature needs to renew it. The other is the preemptive use of it. So let's start with the time-limited nature of it. In its filing with the Supreme Court, the federal government is seeking clarity on this, essentially arguing that if you can just keep rolling over the use of the notwithstanding clause every 5 years, you are permanently stripping an affected class of its rights. Does Manitoba have a position? Do you have a position on that potential for a rolling use of the notwithstanding clause to, for example, keep Bill 21 in place in perpetuity?
Well, I do have a personal position, but let me just make clear that, like, us intervening at the court, we're not allowed to weigh in on a lot of issues, including, Bill 21 itself. I'm sharing my opinion that, Manitobans
Understood.
Oppose it. And our intervention is basically just put it back in the hands of the people. So if we're going to, all of a sudden step outside to the highest level of this conversation, what I would say is my understanding anyways of where the notwithstanding clause came from is almost exactly the opposite of how this conversation plays out in Canada today, meaning that it was positioned as a way to protect the rights of a vulnerable minority from perhaps the overreaches of majority rule. And so some of the examples came from the States. Again, there were times where American judges were striking down laws that might have reflected civil rights as we understand them today for Black Americans. And so the argument was made, from what I understand, that the notwithstanding clause is a way to ensure that a legislature or a parliament could bring forward what we would maybe say are very progressive, very kind of socially just laws. And so I think that the ability to have that notwithstanding clause, the people who rematriated our Constitution, I think they were thinking about a vibrant, bustling, vital democracy that relies on an informed public to be able to shape the direction of where we're going as a society. And so that's why our intervention at the Supreme Court is saying, okay, well, let's keep it in the hands of the people. Let's not just make it entirely at the whims of lawmakers or of the judiciary. Again, a 5-year renewal clause is necessary, but let's say there's a jurisdiction that's electing consecutive terms for the same government. Well, maybe having a judge weigh in and say, were it not for Section 33, the notwithstanding clause, this would otherwise be unconstitutional, and boom, that educated, informed voter has that piece of information to keep in mind before they go and reelect that government again.
So how do you have that dialogue and get to that judgment that you think voters would help voters make their decisions in the future with this pattern of the preemptive use of the notwithstanding clause, where it is invoked before the legislation or the decision is ever tested in court as a way of sort of this constitutional easy button is sort of the way it's being used? Is that a practice that, I don't know if it can be stopped, but should it be discouraged? How do you view it?
Well, I think that what we're advancing would actually address that question, because, okay, let's say a hypothetical jurisdiction uses the notwithstanding clause and they do something that affects a vulnerable minority who's maybe not as big enough of the population to be able to go out and contest the election as a community group, so to speak. They could go to the court and say, court, we know you can't strike this down, but we would like a declaration that this would otherwise be unconstitutional were it not for the notwithstanding clause. And then they can go out into the public sphere and say, hey, look, these are actions that your government is taking that is violating this section of the charter. And they're only getting away with it because of the notwithstanding clause. Now, all of a sudden, the balance of power may be shifted. Maybe that vulnerable minority doesn't have the numbers to tilt the democratic scales immediately, but using the power of persuasion, using the power of building consensus and appealing to the compassion of other Canadians, again, with this important piece of information provided by a judgment ruled on by the judiciary, now all of a sudden, maybe they can tip that balance of the conversation back in a more equitable direction. So again, having this dialogue, we do need the ability not just to have an automatic sunset clause, but potentially for our public sphere to hear from the justices and judges across the country about whether what is being done aligns with the rest of our standards, which are basically about human rights. You know, we're talking about human rights here. So you're effectively getting a proxy ruling on whether something is consistent with our understanding of what human rights are in Canada today.
Just one last quick question, Premier. Things are pretty good at the First Minister's table these days, it seems. Everyone has, found a common purpose there. But various provinces are coming in a collision of arguments, at least at the Supreme Court. And some of the issues that have been, the notwithstanding clause have been applied to on secularism, gender policy, and other things, they are divisive social issues. Are you worried about the reaction to wherever the court lands on this being a possible fracture point for the country? Because there's very emotional stakes in a lot of the issues that underlay all of this.
I'm not worried because I have confidence in the strength of our public sphere in Canada. I think that whichever way the court rules, we will be able to adapt and to respond. So I'm bringing forward another possible path forward, which says that the judges would basically have almost like a referee role, and then it's back up to the people to exercise their judgment through our democracy. And when we talk about First Minister's meetings, I raised this with Francois Legault himself. I said Manitoba is going to intervene. That's the way I handle things, try to all the time, is to deal directly with people. And we'll see where the court lands on this. But I do think it's important for us to think about not just the political issue of the day and having the notwithstanding clause be used to advance that, but rather about our bigger sense of justice, our bigger idea of human rights, and most importantly, our idea of what Canada should be. And so I'm confident that our country, maybe immediately with the decision, but definitely in the course of how we respond to it collectively, that we'll continue to move forward as a country, and we'll stand up for those values that make us so proud of the Maple Leaf, but not pluralized Maple Leafs. You know, I'm a big Jets fan.
Yeah, I gotcha. Thank you for not wearing your jersey today. Manitoba Premier Wab Kinew, we appreciate the time. Thanks for being here, sir.
Thank you.